This series is offered as a partnership between the Hartford Public Library and the Hartford Foundation for Public Giving. My name is Daniel Alexander, and I'm the grants manager at Hartford Public Library. Representing the Hartford Foundation, we have Lucas Codagnolo, Monica Kelly, and Betsy Johnson. Representing the Pro Bono Partnership, we have Priya Morgenstern. Before we start, please enter your name and organization in the chat. Feel free to post any questions in chat as we will address them throughout the session. A follow-up email will include a copy of the slides and a link to the recording. And now I'm going to pass it on to Lucas, which will give us a quick introduction to the Foundation's nonprofit support program. Lucas?
Thank you, Daniel. Good afternoon, folks. My name is Lucas Codognola. I'm with the Nonprofit Support Program at the Hartford Foundation. We are the capacity building arm of the foundation. And so we support nonprofits in our region with any capacity building needs, organizational strengthening needs. And so we definitely encourage you all to reach out to us with any need. And we're so grateful for our partnership with the Hartford Public Library around the series of workshops. And we hope that it is helpful to you, and make sure to share the recording with your board members and stakeholders, and continue engaging with us. Thank you. I'll throw it back to you, Daniel.
Priya?
Sure. Hi, everybody. My name is Priya Morgenstern. I direct the Connecticut program of the Pro Bono Partnership. Many of you know the Pro Bono Partnership already because you're clients, but for those of you who do not, the Pro Bono Partnership is a nonprofit public interest law firm where all of our clients are nonprofit organizations, and we provide legal services to our nonprofit clients on a pro bono basis, which means for free. All of our clients are 501c3 public charities or are organizations seeking to become 501c3 organizations, and they're doing important work in our communities. The way that we work is we connect our nonprofit clients with volunteer attorneys in the community who want to do the kind of work that the nonprofit needs, whether it's contracts, corporate governance, real estate, intellectual property, tax, HR, whatever it may be. We work on a project-by-project basis, and our volunteer attorneys provide legal assistance to the nonprofits. And they're great attorneys. They're from top shelf law firms, such as Robinson & Cole, which I'll be introducing the attorneys in just a minute, or they work in-house at local legal departments of corporations. So our clientele range the gamut from social service organizations, environmental groups, animal rights groups. Maybe you could advance the slide, Abby, if you could. Community support and development, child development, education, the arts, really a very, very wide range of clients. So if anybody on this webinar is with a 501c3 organization, you're not already a client, and you think you might benefit from some pro bono legal services, please do give us a call. Contact information will be available when Daniel sends out the follow-up email. So now it's my pleasure to introduce the attorneys who are going to be speaking today. Abby Warren is a partner with Robinson & Cole and is a member of the firm's Labor, Employment Benefits and Immigration Group. She focuses her practice on counseling employers in all areas of employment law, and her clients include multinational corporations, healthcare organizations, educational institutions, and manufacturers. And she provides a wide range of employment support to all of those clients. She also defends employers in federal and state court and before administrative agencies. And I'd like to give a special shout out to Abby because she's been a volunteer with the Pro Bono Partnership for many, many years and is a trusted advisor to our clients. And we're also joined today by Sapna Jain, who's an associate with Robinson & Cole in their Boston office. She's also a member of the firm's Labor and Employment Group. And she advises her clients on general employment matters, including anti-discrimination and anti-harassment matters, as well as restrictive covenants. She represents clients in various stages of civil litigation, including in federal and state court and before administrative agencies. We're so grateful to have Abby and Sapna providing this presentation today. And with that, I'm going to hand it over to them. Thank you.
Excellent. Thank you, Priya, for that introduction. Priya and our firm, and Priya and I go way back. It's great to be here with all of you. There are a lot of familiar names on our screen, which is great. We work closely with the Pro Bono Partnership, and of course, we're thrilled to be part of this. We hold the Hartford Foundation in the highest regard, as well as the Hartford Public Library. So it's great to be doing a presentation on a really important topic. So thank you for having us. Before we jump in, we're lawyers. So of course, we're going to give you a disclaimer, which is in today's presentation, the information is general. We don't represent you as your attorneys. However, of course, if you need any advice, you know where to find us. Robinson & Coles everywhere. We have we represent a ton of nonprofits in the area. We know a lot of you, so always feel free to reach out to Priya. She knows where to find us, or to reach out. For today's presentation, we're happy to look at any questions that you put in the chat. This is meant to be helpful on a very sticky topic. So Sapna and I have prepared a presentation that is a little bit, it's high level in some ways, but we do jump into some of the risk points to address those, especially drawing from our practice with a lot of our nonprofit clients, and the issues we know crop up in terms of wage and hour issues. If you have anything really specific, we may not be able to take those, at least in this forum, but we're happy to talk offline about any of those. But any general questions that you have, feel free to drop them in the chat. We're happy to address them. In terms of today's format, so we'll go to about 1:30. We know you may be eating your lunch. Everyone's busy, which is totally fine with us. We'll take a 5-minute break, probably 2/3 into the material. So we'll take 5, we'll get our coffee refreshed, and then we'll jump back in, and then we'll end at around 1:30. So with that, we'll jump into today's agenda. So some of the topics that we came up with, of course, Priya's help and Daniel's, we're talking about some of the key wage payment topics. So some of them you'll say, you know, we all know you pay minimum wage, we know you pay overtime, but we'll try to address some of the risk points within those topics, and some of the areas that you may not know. So we'll start with a very high level of those key wage payment laws. The focus today is really Connecticut. We know we're talking to Connecticut's nonprofit community. We may reference some other states, because more and more we have clients that say, yeah, no, I know we're based in Connecticut, but we have this one person, we just couldn't find the skill set, and they're located in California. We say, whoa, okay, now California law applies. That's how, in our world, that's how it works. Wherever the person's sitting who's working for you, those are the laws that apply. So here and there, you'll hear us say, you know, if you have somebody across the border in Massachusetts, but largely this is Connecticut focused. We'll talk a little bit about exempt and non-exempt, which of course is one of those favorite topics, that there's a lot of landmines there. We'll talk about independent contractor versus employees, and then we'll lightly touch on interns and volunteers, knowing our industries today are mainly nonprofits, and you may use interns and volunteers and those sorts of folks. So with that, we will jump in. And I will hand it to Sapna to get us started.
Thanks, Abby, and it's so great to be with everybody here today. As Abby said, we love working with you all, and you know, employment law keeps us busy, and we know it keeps you busy. So we hope this will be helpful today. So we want to start today sort of talking about wage payment laws, and we're starting with employees. And the reason that it's in quotes is because we hear a lot about employees versus independent contractors versus interns versus volunteers. So all categories that we're going to touch a little bit on today, but here when we talk about employees, the assumption there is going to be that these are W-2 employees who are working for the nonprofit. So that's sort of what that looks like. And there are obviously state and federal laws, and employers have sort of legal obligations related to a variety of these things. So for employees, it's not only wage payments, taxes, but a lot of states recently have introduced sexual harassment and discrimination training requirements, especially in light of the Me Too movement. So those things are definitely things to think about. And we'll get into this a little bit more, but you've got employees who are classified as exempt or non-exempt, and those exemptions or those categorizations impact the legal requirements sort of relating to wage payments. So do you have to keep track of all hours worked? Do you have to pay overtime? What does the record keeping look like? You know, if somebody's changing their schedule, how does that look? So all of those things sort of play into that. And for nonprofits, you know, it may be a more limited set of legal duties and requirements, but relating to volunteers or independent contractors, but we want to make you aware of all of that, just so that we can avoid as many issues as possible. Abby, next slide, please.
Okay, so a quick note about nonprofits. The nonprofit industry has a lot of interesting carve-outs throughout federal law and state law. Most of the laws that we talk about today do apply to nonprofits, but just know that if you are running a summer camp, if you have individuals with disabilities, if you have a religious organization, there's a ton of carve-outs, whether we're talking about wage payment, unemployment, Connecticut paid sick leave law. So whenever we have a client that's in a specific industry, there may be some sort of carve-out or some different law that says, oh, if you run, for instance, if you run a summer camp and you're not open that much of the year, you may have a different set of rules that apply. The overarching rules we'll go through today, we won't go through any of those really specific areas, but just know that they're out there. So I don't want anyone to say, I run a summer camp and I'm doing things differently, and they just said that everybody's got to get minimum wage and overtime. That may not apply to you. So again, I'm happy if you reach out to us or to Priya, but don't think that we're speaking to a lot of those more nuanced issues, because today we're really talking at a high level what applies to most kind of run-of-the-mill nonprofit organizations.
So minimum wage, this is this topic has been in the news for some time, with constantly changing minimum wages on the state level. So if an employee is classified as non-exempt, you know, that's where they're paid hourly. And so the Fair Labor Standards Act sort of establishes a minimum wage at the federal level, and that's that also lays out the overtime pay, record keeping, and some other requirements that are required, obviously requirements required with minimum wage. So you want to keep those in mind sort of as a baseline. And then with the federal minimum wage, that's $7.25 an hour. But like I said, Connecticut state minimum wage just increased this year to $15 per hour for beginning June 1st of 2023. So you want to keep in mind both the federal and state, and typically we advise that you go by sort of the state minimum wage, which is more often than not the higher minimum wage, because employers are required to be in compliance with that. So again, while this is Connecticut focused, if you're in other states, you definitely want to check to make sure that the minimum wage requirements are, if they're changing, then you want to make sure that you're compliant with the most recent ones. So again, generally, minimum wage must be paid for all hours worked for non-exempt employees. And so what does that look like? That's when they're obviously working, but I'm sort of jumping to the last point here, when they're on site. But you want to also think about, is there required training? Are there other circumstances? In some cases, we've seen, you know, travel time, not your normal commute from home to work, but are you going to, are you driving a group of people to a client site? Are you visiting a group home? So you want to be mindful of what that looks like. The other thing, I'll sort of jump back and forth here, but relating to record keeping. You know, we have this question. So should exempt employees record all their hours? You know, not really, but the very, very lawyerly answer here is it depends. You know, not necessarily for paid time or sick time, but there may be another business reason why exempt employees might need to record their hours. It may be, you know, a client would like it for invoicing purposes. Maybe a grant that's supporting the work requires a detailed listing of how hours are being worked and who's working on that. So you wanna ask sort of what the reason is. And just as a note, this sort of, I'll pull this into the next one, but for if you have different rates for people working, so you may have counselors who are, you know, you're paying them $20 for while they're during the day and they're managing children and that sort of thing. But then sort of post camp hours for cleanup, there may be a lower wage rate, you know, $15, which is the minimum wage in Connecticut. You want to really think about, you can do that, but you want to think about sort of the other ramifications of that and sort of the need for blending overtime, which is what we'll get to next. So on that point, if you're going to be blending time, we would recommend that you reach out to counsel to make sure that it's very clear sort of what's happening there. So overtime, time and a half is for non-exempt employees, any hours or each hour worked in excess of 40 hours in a work week should be paid for 1.5 times the regular rate of pay. So work week, we all think maybe sometimes it's Monday to Friday, but for those who have people working on the weekends or, you know, if there's big events, you want to make sure that the work week is clearly defined. You know, usually it's Friday to Saturday, but if you have somebody working maybe 15 hours on a Saturday or over the weekend, you want to be mindful of that. So that gets taken into the overtime calculation. And here I will sort of get into this a little bit later, but you want to be mindful of how minors factor into the hours that somebody might be able to work in overtime for minors, and what those calculations require.
Okay, so we have a couple slides of questions taken from our desks. So here, the first one we're going to talk about is an employee who works in an organization providing services, occasionally works in the gift shop. So this is someone who might be providing services of childcare, care for folks in a group home, something like that, but there's some place where items are being sold. If the person gets commissions, they get their minimum wage or they get wages, but they're also getting commission on time sold. Does that impact regular rate for purposes of overtime? So the person works, you know, 40 hours, works another 10 hours. So we've got 10 hours of overtime and you're at your desk and you're thinking for payroll purposes, you know, person made an extra $100 that week in the gift shop. They were really selling, you know, whatever the item is, but also got the regular rate for all hours worked as well. The answer is yes. So one thing that a lot of people don't realize is when you're calculating overtime, if you have folks that are making money in different ways, so they're making some sort of bonus structure weekly or something that they can count on. So something that isn't discretionary, like commission typically isn't. If you sell one item, you get 5%, you get 2%, whatever it is. Those sorts of extras do actually impact the overtime rate just for the week when they're earned. So if our star employee here works and gets commission 1 week in the month, then in that 1 week, if he works overtime, we would actually throw all of that in the calculation. And for that week, the overtime is actually at a heightened amount. It's something just to keep in mind. It comes up here and there. And we certainly see it where someone says, hey, I've been doing extras where I work at the aftercare and I get an extra $100. And so those sorts of monies, you just have to be careful only for people working overtime that you're calculating that properly. Let's do another one here. So we have our employee who's a go-getter. So they check out for work every day, they clock out, they're non-exempt, and they check the organization's mail. So just a few minutes, if we look at the total amount of time the person is logging after hours, going and checking the organization's mail at the post office, we're talking 2 extra hours. What do we do about those 2 hours? The answer is really clear. That is for someone who's non-exempt, who's hourly, who gets paid for time worked. That should be time worked. To me, 2 hours is not tiny. It's not de minimis. That's hours worked and it should be paid. In the nonprofit world, you have a lot of people who are so committed to the mission that they volunteer a lot more than maybe a law firm. And so you have to be careful of that, that when people are volunteering, when people say, don't worry about it, I'm happy to do it, it's no time at all, that we are capturing that time. They are telling us, yep, adding an extra 10 minutes, 20 minutes every day, and that they are being paid for that. So just something to keep in mind. Non-exempt part-time, if they work 25 hours, do they get 5 hours of overtime? That's a good question. I love it, Priya. Yep, overtime only ever kicks in at 40 hours. The way to think about this is these overtime laws at their heart are Depression era laws that were meant by the government to say to employers, at 40 hours, we're going to charge you more money, which means you better hire somebody else. So that's where they come from. They come from that sort of mentality. So I have clients that are always trying to say, well, what if they work 50 hours in 1 week and 30 the next? Nope. This is a work week. It's magical. It's, if it's Friday to, it could be Monday to Friday. It could be really Monday to Sunday. In any of those work weeks, if somebody works 40 hours and they are non-exempt and they're entitled to overtime, they need to be paid at time and a half. There's not a lot of ways around it. I've been to the DOL in multiple states. I'm really good at what I do. I have a really hard time finding a way around it. So it's pretty clear. It's one of the only areas in wage and hour that's patently clear. And it never kicks in for people working under 40 hours. Okay, a couple more questions. An employee tells you that she knows the organization is a nonprofit. She is happy to work overtime at her regular rate of pay. So you pay her $15 an hour. She says, look, I know this is a 50-hour-a-week job. I'm happy to work all 50 hours at my regular rate of $15 an hour. Are you able to say, well, that's great, let's do that. I'll have you sign something, waive your right to any overtime. This is a match. This is great. The answer, oddly, is no. So the government doesn't really trust employers. So those waivers are worth nothing. You are not allowed to do that. Even if somebody says it's my time, I believe in the organization and I want to do this, doesn't matter. So it's it's pretty unforgiving. And we sometimes do have this come up again. It usually comes in where a mission is involved and someone really wants to be helpful. But it's incredibly unhelpful to you because if Connecticut DOL comes in and says, whoa, what's going on here? We get ourselves in trouble and there's really steep penalties that are connected with failure to pay overtime. So just something to keep in mind on that one. I think I've continued with the theme
Abby?
here. Yes.
Abby, there's a question I want to throw out to you that came in through the chat. For exempt employees, would travel time be considered working time? For exempt employees.
Yeah, I mean, if you're exempt, it doesn't matter if it's working time or not, because it wouldn't impact your pay. So if you're making, you're the director of development, you make $60,000, we're not tracking your working time. So there's no real concept of working time. In a working time means, extra pay. So there would be no extra pay. If you've got a position and someone's saying, look, as director of development, I want to be honest about how much this job actually entails, travel is absolutely part of it. So if you're driving to different schools or group homes or driving around the state, other than a normal commute, I mean, that's working time for purposes of like, look, this job is 60 hours, like at least if you don't want the job, let us know. But I would certainly consider that from like a job description or marketing perspective. Working time absolutely includes any non-commute kind of travel time.
Thanks.
I would also say if it, you'll have to look at the terms of like your grant or any other things that may be relevant to sort of invoicing and keeping track of time. So it's what are the requirements there. So that's another thing to just keep in mind.
Yep. So then in my example that keeps going here. So the person says, look, I want to work the 50 hours. I'm willing to just volunteer the extra 10. We can call it 10 extra hours of volunteer time, 40 hours of work. This is someone who says, I work in development, I'm non-exempt. I want to do 40 hours and then I want to do 10 hours of exactly the kind of work I'm doing for the rest of the week. So I just want to work 50 hours and I'm happy to do that. Answer is still no. Typically, you can't really volunteer for the same work you're actually doing for the organization. So if you're working in development, you're running down calls, you're talking with donors, you can't volunteer your time. That's time worked. And even if the person says we can write it up that way, no, we can't change it that way. Now, on the other hand, if our person is working 40 hours and then the organization is having road races and says, hey, we'd love for people to volunteer. Don't care if you show up or not, just something fun. If you want to do this, this isn't, mandatory. Absolutely. True volunteering like that isn't an extension of the person's normal duties. That's fine. But we can't find ways not to pay people. And the last one is, what if she says, I've solved your issue. I'm just not going to put down my time on my timesheet. No, that is off the clock. All time work has to be recorded. It protects you. In these cases, it is your burden as the employer to have time records. And when you don't have time records, the burden is against you. So someone says, what kind of an organization are you running that you don't have time records? So believe it or not, I've used people's diaries before where someone says, yeah, no, I have this diary where I would write things down when I would see people coming through the door and I record their time. And I've had to rely on all kinds of crazy evidence to convince the government when my clients haven't actually kept records. Don't make me do that. I love time records, clock in, clock out, breaks over 20 minutes. Everybody records their time. Keep it simple if people are non-exempt. They're owed that. And again, the penalties are very steep in this area.
Can I add something here? Especially now with smartphones and people able to work wherever they are. I think it's particularly difficult some people just really want to keep checking emails and keep working. And sometimes as an employer, it's very counterintuitive, but sometimes as an employer, you have to tell employees they cannot work past their hours in the office. They can't be checking their emails from home. And these are people, they're mission driven, they love the organization, they want to work really hard. And you really have to tell them they can't because they're putting the organization at risk. And I just think for a lot of us, it's hard to do, but it's important. Thanks.
That's a really good point because that's coming up constantly. And the vacations too, where someone goes on vacation but keeps checking and checking and checking. And we're talking about hourly employees. So, your exempt employees will get to them, but the executive director, the C-suite, the director level that are all exempt, they're going to check their email on vacation no matter what. And a lot of you on the call are doing that too, probably when you go on vacation. But for the hourly folks, if it's de minimis, if you can't find something, you say, oh my gosh, I've got to call the receptionist because I have no idea where they put the invoice for the vendor. Fine. You make the call and that's fine. But if they're working through their vacation, they really should be paid. And so I love what Priya said. And sometimes with our nonprofit clients, we say, you have to sit that person down, the receptionist that's like, I'm just going to stay. It makes me feel better just to get my work done. To say, look, part of our mission though, is to treat people fairly. And I want you to work and be paid for it. And we budgeted for this amount. So, allow us to fulfill our mission to our employees as well, not just to those that we're serving. But it's difficult. The other thing I thought Priya was going to go in this direction too, which she made me think of, is there's a lot of easy apps that you can use now. So, the old days of walking in and doing a time clock, some people still do them, or they say, look, we have it on everyone's monitor on their desktop. We want people to come physically in and clock in. But a lot of the ADPs and payroll companies of the world have multiple ways that you can actually record time. So I have a number of clients moving to apps. So if somebody wants to come in and record their time on their computer, that's fine. But there's also an app. So if somebody, starts their day earlier and does an hour at home and then comes in and you allow that, it's easier to capture the time to say, let me just do it on my phone, put in that hour. And then when I get to work, I'll continue and I'll log on the hours in another way. So that can be helpful. The last one here. So when the organization holds events, employees tend to work substantially more hours. And we know a lot of you throw wonderful events, and during event season, the weeks leading up to it, people are working a ton more time. So what happens if you try to use a flex time model? So you say, look, if you work 50 or 60 hours, you're really, going at breakneck speed, working a ton of hours, and then you work 20 or 30 the next week, we're going to average them. So we pay bi-weekly. As long as you work 80 for every 2-week span, you're fine, right? No. Again, these come from like the 1920s, these laws. They say the work week is all that matters. They don't care if you pay semi-monthly, monthly, bi-weekly. It always comes down to just that week. So the flex time really doesn't work, but it works during the same week. So sometimes I'll have clients say, if somebody works really hard Monday, Tuesday, 12 hours, these are the days that we're planning this event, or we're, the whole team is kind of caucusing and putting the final touches on something. Can they work less hours during the end of the week? Absolutely. You can work 12-hour days as long as by the end of the week, we calculate our overtime and we start paying at that magic 40-hour time period. You're fine. The flex time just doesn't work for non-exempt. It can work for exempt, where you say, look, we know for our exempt employees, they work a lot. I know a lot of people that work for the session up here in Hartford. It's like after session is over, the employer kind of looks the other way and is like, right, Priya knows, exactly. It's like, take the summer, regroup, but during the weeks leading up, they may be working 80 or 90 hours, but that's an exempt employee model. And that's actually what it's designed to do, is to have an enormous amount of flexibility for those decision makers, higher level folks. It is not meant for the non-exempt employees.
Abby, we have a question here, I think of general interest. Somebody asks, occasionally they need to text or phone a non-exempt employee at home on a day off to ask about something that may have happened when that person was working. And so the person's asking whether those 5-minute phone calls or texts need to be accounted and paid for. Can you address that, please?
Yeah, we always call it like de minimis, when it's very little and it's something that somebody can pick up the phone and say, yes, it's in that drawer. Oh, I forgot the roofer was coming. I put that check in that folder. That stuff, it's never going to be an issue if it's like 5-10 minutes for the week. A few minutes a day, you start to get me thinking, 5 minutes, now I'm thinking that's like 30 minutes for the week. But if it's sporadic, I don't worry at all. I don't have a lot of clients that do, either it's de minimis or it's not, because I have the clients that bug a lot. They're kind of bugging, and you're like, oh no, like you're calling nightly. If that's the case, we should probably start to figure out if we should adjust and pay for the extra time. But little stuff like that, I don't worry about, from a wage perspective. And I haven't had anyone say that. The ones of the, I've had so many of these off the clock, and it's never that. It's always, I go home and they know I write the emails. Well, how do you know? Well, I'm emailing everybody, so they know I'm doing it at night. You're like, okay, fair enough. Like, we can see your email timestamps are for an hour. We know you spend an hour of emails at night, but the client says, well, we just figured they didn't care. And you're like, oh no, but the government cares. So I wouldn't worry about the little stuff.
Thank you.
Okay, those are great questions. Okay, I'll turn it back to Sapna.
All right, so deductions, as we've sort of talked about generally, the government doesn't necessarily trust employers. And so especially with deductions, there are lots and lots of parameters around that. You have to be very intentional about sort of what deductions are being made. And here we sort of draw your attention to, in Connecticut, that aside from circumstances that are listed in Connecticut or federal law that allow an employer to do so, the employer has to get written authorization from the employee on a form, and it has to be approved by the commissioner of the Connecticut DOL. So it doesn't have to be approved for every single instance that this happens, but it does have to be for sort of overall situations. Those have to be approved because generally these deductions are for, health and welfare of employees. So think about health insurance, that sort of thing. So be very mindful about deductions and sort of how to go about that. If there's a question on can you deduct something or not, it's worth giving council a call to figure out, just to talk through what that might look like. And we've seen our fair share of deductions, so we're happy to always help walk through that. And then frequency of pay. So, you know, in Connecticut, employees must be paid within 8 days after the end of the pay period. I will note here, if it's a situation of an employee being terminated, there's exceptions to that. The timeline is a bit accelerated. And the other thing to think about is, you know, if the payment schedule is changing from weekly or bi-weekly, if it's changing one way or the other, you want to make sure that you give employees proper amount of notice, so that they're not surprised when, you know, they may be expecting their pay. You know, if you're moving from weekly to bi-weekly, they may be expecting it and then not getting it. So you don't want surprises there, because this is an area which there's definitely exposure for liquidated damages. And you want to call counsel early on to make sure that you're not running into any issues with missing wage payments.
Okay, lunch breaks. We'll do a couple quick slides here. All of you probably know this. In Connecticut, if you work more than 6 hours, absent certain exemptions, people get a 30-minute lunch break. They should be relieved from all of their duties. They should be able to leave if they want to leave. They should clock out. So employees who are taking more than a 20-minute break, you can ask them to clock out. Under 20 minutes, that is time paid. So we can never have, you know, oh, I give 15-minute breaks, but I have them clock out. Nope. People should only be clocking out if they're taking a break more than 20 minutes. For lunch in Connecticut, if someone does want to take their lunch and you're fine with them not taking their lunch, you can absolutely let them waive it. And just get something in writing. So some of the payroll companies, because I've looked at the interfaces before, some at the end of the week when someone says, yep, my hours look good, I'm confirming, it has a box that says, I voluntarily chose to waive my lunch break, and people note it. So if you do it on a weekly basis, for my purposes, that's fine if it's somebody who's doing it every single day. For people who just decide certain days, I just don't want to take lunch, I want to keep working, just work with your payroll company and have something there that says when I'm reviewing my hours for the day, that I can confirm that I voluntarily waive my break. So we get this a lot. An employee says, I'd rather leave work early. I'm going to eat through my lunch. I'm going to sit at my desk. I'm going to say goodbye 30 minutes early. Can you do that? It's up to you. Most of our clients say, why not? If somebody doesn't want to take lunch, I'm not going to hold them at their desk till 5 o'clock. If they're a good worker, let them leave at 4:30. Perfectly fine. Just find a method where the waiver is in writing. Again, it doesn't have to be clunky. If it's someone that says every single day, I don't want to have my lunch, just have them do it through payroll. The payroll systems are really good and make it simple to be able to do that. A lot of these slides, we kept them a little bit on the heavier side because they're really good resources for all of you. And we know the folks on this call are probably people that have to deal with a lot of these issues on a daily basis. So I won't go through minors and the issues there, but this issue of child labor is a big one. So if you've got people 15 and 16, 17 and 18 working, just know what the restrictions are. Depending on the industry, there are different ones where, some restaurants, you can be doing certain things, but you can't be chopping, you can't be working with a blade. So just know whatever those are, when they can be working, what they can be doing for whatever, wherever your organization is working, just know what those are and be able to comply. And then a couple pitfalls that I wanted to note. So each of our sections here is a few pitfalls. One of them with wage payment is an issue of classification. So one of the biggest issues is classifying people as exempt who shouldn't be, which we'll go through. Another is, of course, the offer, taking an employee's offer to volunteer, not record time, all of that good stuff. Another one is offering other payment rather than wages. So gift cards, free items, all that is good. You might be running an award program where you give those out, but when you're actually paying people for time worked, we can't be bartering. We can't be giving the fun stuff. We've got to be giving their pay. And then one thing that I do see sometimes is avoiding a formal timekeeping system. So a lot of times people say, well, people don't want you breathing down their neck, so my whole workforce is exempt. I say, wait, everybody's exempt? Yes, from the receptionist to the executive director. I love that Priya's shaking her head. She knows. That happens a lot. And they say, but the employees don't want us breathing down their neck. No, you have to tell them, especially as a nonprofit, I want to do the right thing. There are laws that are in place for a reason, and I have to follow them. I may not agree, but I have to follow them. And part of that is having a formal timekeeping system. So a few things to keep in mind. So we're going to talk very kind of briefly about exempt versus non-exempt at a very high level. We have a lot more slides than we plan to go through in too much detail, but we are going to talk to you about kind of the top 3 exemptions and some of the things to look out for, especially in the nonprofit industry. So I'll turn it to Sapna.
Yeah, so with that, so we've talked a lot about non-exempt employees when we talked about sort of wage requirements. So now we're looking at sort of what is the difference between exempt and non-exempt. So exempt employees, you know, a big part of it is that employees who use discretion and judgment on a regular basis. And we'll talk through what the exemptions are, but these employees are not generally entitled to overtime or minimum wage. And the key thing to think about here, which Abby referenced, is the default is non-exempt status. And so employers have to show how they're satisfying an exemption. So that's always something to think about. And, you know, a big thing here is misclassification can be incredibly expensive. So you really, really want to make sure that you are abiding by sort of going through the process of making sure that people are properly exempt or non-exempt. And 2 parts of that. So again, we'll go through a high level summary of some of the examples, but 2 of the tests are, one is a duties test. So, you know, are some of the frequent, or I guess some of the most used exemptions are the executive, administrative, or professional exemptions. And it's not just controlled by the job title. You really have to look at what people are doing. And then the salary basis test. So generally that's $684 a week. But there are some exemptions, and sometimes there are, you know, there are some exceptions to the salary basis test. But again, as a general overview, that's sort of what guides us.
I have a question, Abby and Sapna. Can you go over the risks or the exposures to the employer if they characterize somebody or categorize somebody as exempt, and so that person is not paid overtime, but then it was a mistake, intentional or otherwise, and that person should have been receiving overtime? What are the risks? They probably have to pay what was owed, but there's additional penalties, correct? How does that work?
Yeah, so it's funny you should ask that, Priya. We actually have a whole slide on that later.
Oh,
and
sorry.
So you're thinking ahead, and we love that. But I'm just going to hang tight to that question because that falls into one of our potential pitfalls. So, in terms of the primary exemptions, you know, they're sometimes referred to as the white collar exemptions, and these may be, you know, think about your executive director, somebody who's supervising. So that may be somebody who falls into the executive employee category. When we think administrative employees, they may not necessarily be supervising people, but if you have sort of a C-suite director of development, other types of people who are doing more administrative work, but may not necessarily be supervising. And then we've got sort of professional employees. So high-level graphic designers, creatives, other types of people who fit into that category. And we'll dive into these a little bit more as we go through each, but there are other categories such as outside salespeople, highly compensated individuals, but the white collar exemptions are sort of the 3 main ones that we want to touch on.
Okay, so we'll go through these in a little bit of detail. As Sapna said, there's a lot of exemptions, but there's kind of 3 primary ones, especially in most of your organizations that you're going to make use of. And to kind of take a little bit of a step back. So in your workforce, everybody's got to be non-exempt or exempt. I sometimes have clients that say, and then we have these other people. I'm like, no, everybody's exempt or non-exempt. The temporaries, well, they're non-exempt or exempt. So these 2 basically transcend whatever other classifications you may be using. Everybody's got to be one or the other. If someone is non-exempt, they have to be recording their hours. They have to be paid overtime at 40 hours. Those are non-negotiable unless there's some exemption or something else going on. If someone's exempt, the issue is they're not putting their time down. So to Priya's point, if you say someone's exempt and you say, yeah, that receptionist, we're going to say they're exempt, they're not recording their time. So the biggest issue that we come across is the receptionist is fired, isn't doing a good job, and wants to basically bring a claim. And one of the claims will say, well, that's really interesting. I got fired and I was exempt and I was working 60 hours a week. And you're thinking you barely worked the 25 we were paying you for, but lo and behold, you have no records. And so that's when defense attorneys like me get involved and we say, well, what do you have? Do you have cameras? Do you have footage? Do you have beep, beep when people are coming in and they're in the parking garage? So I've got to rely on tons of wacky evidence, and the government's all the while shaking their head saying, well, you shouldn't have done that. You shouldn't have characterized them that way. So it's kind of a funny rub that you get into because you don't have the records because you've taken the position they're exempt. And it's massively expensive when you do that. So what do our exemptions look like? The first big one is the executive exemption. Anybody who is regularly, basically is a supervisor to 2 or more people is typically going to be an executive, and typically we're going to be able to say they're exempt. So the number one person in most organizations typically going to be an executive exempt. A lot of times your C-suite that have multiple people reporting to them, they're probably going to be able to be exempt under the executive. If you have like a big department, so you may have multiple layers. If it's a big nonprofit, you have 1,000 employees, couple thousand, you could have multiple layers of executive, but at some point when the organization is flattening out, they're not executive. They're not regularly telling people what to do. And when you're an executive and you're classified this way, you actually have to have certain authority. So it can't just be someone who's, leading a shift, or we sometimes have team leads, shift leaders, people like that when they're on, you have to listen to them, but they're not doing performance reviews. They're not hiring, they're not firing, they're not actually supervisors. They're definitely not executive. So it has to be kind of like your true executives that are actually leading a team. Administrative is the second kind of major one. Administrative means that you are running a part of the business. So suppose you have a development function that's very high functioning, but there's only 2 people in it. You have a director and you have a person reporting to that director. But the director basically runs development. They are running strategy. They are basically running that part of your mission. That person is probably going to fit the administrative exemption, won't fit the executive because they're not managing 2 or more people, but they definitely will, assuming all is well and that they fit this category, they're probably going to be part of the administrative exemption. A receptionist is not. They are not running the business. If it's a typical receptionist who's running the calendar, running the office, that's not going to be administrative exemption. If you have an office manager, though, who's using a ton of discretion, who's negotiating contracts with vendors, who's making a lot of decisions in the office, which impacts the business, that person could be administrative. But kind of someone who's more run-of-the-mill, who's not actually running a part of your business at that level, not going to be able to fit this exemption. Administrative exemption is the most abused of the group. So it's important to know like where the line is there. And then we have 2 on professionals, and I'll throw it to Sapna on these 2.
Right. So with professionals, so this, at least first there's the learned professional exemption. So this is somebody who requires advanced knowledge. So that looks like an advanced degree, some sort of field of science or learning. Think teachers, lawyers, engineers. So somebody who's brought in for their particular expertise, and they're sort of using that specialized intellectual education. So, or the instruction. So that's sort of the first one of the 2 learned of the professional exemptions. And then we have the creative professional exemption. So here it's more of a creative focus or an artistic focus. So think actors, writers, directors. So that's sort of more of a general, those are some examples that may fall into that. But again, you want to really look at what they're doing, and do they fit into this category. With graphic designers, though, sometimes they fall into a creative professional category, sometimes they don't. So you really want to make sure it's not just what the job description says, it's what they are actually doing. That is one of the most important things.
And you may be asking yourself, so we have all these legal tests, like, what am I actually supposed to do? I think the one thing you're actually supposed to do is, if you haven't looked for a while at how you've categorized folks, take a look. This is an area that there's a lot online, so you can actually kind of do it yourself to go through the tests and say, yep, be honest. If you don't say people have discretion when they don't, but just know for each position which category they fit under. And if you're sitting there thinking, why did we do that? This is someone who, you have camp counselors and you have one person that watches the camp counselors, but it's not really an executive. It's a nice position. It's something that's always been exempt, but we're not sure why. That's an area to say, if we're not sure why, let's figure this out. One thing we don't address in the slides is, well, what happens if you find out somebody is misclassified? There you call PREA, or, you call counsel, because you're going to be making a change and someone's going to say, whoa, I've been working here for 10 years and I've always been exempt. What's going on? And why am I all of a sudden getting overtime? So before making that, to me, is a very high risk decision. So I would certainly kind of get advice around that, advice on whether or not to make the change, but also how to make the change in a way that makes sense, is legal, but also just makes good business sense. So a couple hypos here. Organization is struggling financially, and an employee who's a receptionist offers to be paid a salary in order to save money. Can we do that? This is an interesting one. After we've spent this whole time talking about the fact that non-exempt employees get minimum wage and overtime, I'm going to tell you something else. You can decide, if someone is only ever working 40 hours or 35 hours, you can decide you want to pay them in a flat rate. It just has to be at the, at least minimum wage, at least overtime, and they have to record their hours. So if somebody always works 8 to 5 and you say they never work more than that, I'm going to have them recording their time. And if they work 30, 25, 35 hours, I don't care. I'm going to pay them for 40. Totally fine. You only end up really running into an issue if people work more than 40 and you haven't put that in your calculation. So if you have somebody who's working 50 hours and you say, I'm going to pay them $15 an hour for the first 40, I'm going to pay them at their overtime rate for the additional 10 hours they work, and that's going to be their rate, then as far as I'm concerned, you're fine. They're working their 50 hours, you're paying them enough. It's kind of a fake flat rate because it's really just based on, the regular rate and overtime. No problem with that at all. If in our example, our receptionist is working tons of hours and is just going to collect a salary, isn't going to be recording hours, and then we're going to have somebody just who might be working overtime and is probably not getting paid properly, we can't do that. And again, that person can't waive their ability to actually make minimum wage and overtime in that case either. So we have a lot of clients that use staffing agencies. So you say, look, I employ a lot of people. I'm going to get a couple people from a staffing agency for temporary help in the summer, temporary help on a project, and I'm not going to be responsible for them. So what if you decide to do that and they provide you with a receptionist? Can you pay the staffing agency a flat rate per week? So the answer is yes, right? This is a business-to-business contract. Hopefully an attorney read the contract and it says the staffing agency has to follow all the laws. The staffing agency is paying properly under state and federal law. And as long as all of that is in there, and of course, lawyers like us like indemnification, which says, and if they're not following the law, it's all their fault. And they're responsible for it. But as far as I'm concerned, that's somebody else's employee. And as long as your documentation is what it should be, that's fine. That to me is very different. And you're not actually you're probably a joint employer, but you're not the employer of record in that case. So that's a little bit different than your own employees who are on payroll. I think I answered the first one. Can you reduce the salary of an exempt employee who is underperforming? The answer is yes, you can do that. You can probably, well, the answer is really no. At a high level, when someone is exempt, they are paid a salary regardless of the quality or the quantity of their work. So you can't be changing their salary on them, because the whole point is if they work 100 hours or they work 20 hours, they get the same amount no matter what for those weeks. If they're terrible and they get a 1 out of 5 on their performance review versus a 5 out of 5, again, they always get their salary. If for some reason you need to change their salary, it has to be for some other reason. So what if during COVID, we had a ton of clients that said, look, I've got to reduce everybody by 20%. As long as they're paying at least that $35,000 per year, you can reduce their pay. People don't like it. You've got to give advance notice. So there's a couple things you need to do. You can reduce it for that reason, but you can never change their salary based on quality or quantity of work. If someone doesn't work at all for an entire week, you can say, you don't get your salary if you had no PTO, no paid time, but you can't just say, wow, Abby, last week that work was terrible. I'm going to pay you half your salary because that's really all you earned. That's unlawful. And I think we answered the last question. So a couple more slides. This one is really tips for classifying employees. A lot of this we've gone through, but just be cautious of the job description. So the job description is the #1 place that I look when someone says, hey, can you look at this job description? My director of development, I always said it was exempt. Can you take a look? And I read the job description and I literally go through all the tests. I circle, I underline, I say, well, based on this job description, this really isn't exempt. So either we need to figure this out and fix it, or your job description just isn't very good and let's fix the job description. So just be cautious and make sure those job descriptions really show the discretion, the supervision, all the things that people are actually doing to be able to be classified as exempt should be in that job description. Same with titles. So when I get titles, like someone says, well, they're a receptionist, and I say, okay, that's probably non-exempt. But then the person is really describing a high-level office manager or like an executive assistant that's really running a portion of the business. Then I start to say, okay, well, the title's not good. Let's fix the title. But that job might fit one of the exemptions. One here that's interesting, reporting structure matters. So depending on the exemption, you want to make sure that wherever they fall in the organization, that it makes sense. So if you've got someone who's running a department, it has to kind of show that from an organizational structure perspective. And so there may be fixes there that, we've got to make to ensure that these descriptions and the actual jobs being done really are exempt. Quick note on managing exempt versus non-exempt employees. A lot of this we've gone through, so I'm gonna slide off. I will leave this to you to take a look at. And the last slide before break, I promise, is exactly what Priya wanted us to address, which is how costly is this? Suppose you have 20 employees and you've decided everybody's going to be classified as exempt, even though we know a couple people shouldn't be. Eventually, this typically comes up from a disgruntled employee that calls the Connecticut Department of Labor, calls the Federal Department of Labor and says, hey, I was classified as exempt. I'm non-exempt and I was working overtime. So the key is if they were working overtime, if that happens, what'll happen is the DOL will do an audit. They'll audit everybody who's similarly situated. So if you have 5 receptionists and they were all classified as exempt, they'll review that. And if they reclassify it and say, those people should not have been classified in that way, everybody who fits that category, they'll reclassify and they'll do back pay. So they'll go back and try to figure out and Daniel, I got a nod out of him there. This comes up a lot where someone says, okay, we're going to recreate those time records. If they say they work 60 hours a week and you have nothing, they accept wholesale that the person works 60 hours a week, which is why people like me then are looking at napkins and diaries and cameras and things to figure it out. But they'll go back. You can pay double damages. There's attorney's fees that go along with this. There are fines and penalties. There's interest. So in my world where I do kind of all things employment, this is the most costly is wage and hour, because when you don't pay people properly, it's seen as kind of the highest violation of law. Look, the person was working for you. You had all the knowledge. You should have followed the law. And so the liquidated damages, double, can be triple damages, are really expensive. In COVID, I would get calls from people saying, I'm not going to make payroll. And I would say, well, let's talk about your other expenses, because we need to make payroll. That's a non-negotiable. So that's kind of the way to look at it, because it's too costly. and then people don't trust you, right? If you miss payroll, if you misclassify, people say, wow, I didn't know my legal rights, but you should have. And so it becomes extremely problematic.
Hey, Abby, there's a question that came in that maybe you can address. Somebody asks whether exempt employees, must they be paid on a fixed salary basis, or can an exempt employee be paid on an hourly basis, acknowledging that they're not entitled to overtime, but they're paid somehow based on how many hours they work, or is that just not part of the definition? Can you address that?
Yeah, that's a great question. The answer is no. So when the government went and made kind of this non-exempt category and tried to force employers to hire a second person, that's what it's meant to do. It's meant to be a penalty. And my clients sometimes kind of wrestle with that terminology, but it said, look, owners, people who are running your business, who, if everyone else quit, they would still be standing, they'd still be running it, the executive directors, the C-suite, the executive leadership teams. We can't be doing this, we can't be levying that kind of penalty. We can't be doing this overtime. They allowed those people not to be paid, minimum wage overtime, but it's because they work a ton and they use their discretion. And because of that, the benefit of being exempt is you get paid no matter what. So as long as somebody does 2 hours of work in a week, they get paid. So there's not really a way, if somebody's exempt, to really pay by hour. You can back into it. You can say this is a 50-hour job, typically, might be more or less. And so you may set your comp based on what you think the job is worth, but you really can't have people putting down their hours for purposes of pay, because at that point you have to pay them that rate every single week. And when you mess around with it, you start to erode your ability to claim. You basically waive your exemption.
Thank you.
Okay, so with that, it's I guess that's the top of the hour. So I think we'll take a 5-minute break and then reconvene for a couple other issues. We'll kick off. Oh, our recording's in progress. Great. We'll kick off the next 2 topics. We're going to talk a little bit about independent contractors versus employees. So up until this point, we've talked a lot about employees, which we've got our wage payment laws, we've got our classifications, we've got those requirements. And then we have independent contractors, which are very different relationships. These are non-employees. These are business relationships generally. But there's some issues around, are we classifying them properly? Should they really be employees? When can we use independent contractors for grant writing, to help us with donors, for event planning? We know a lot of nonprofits have a list of different folks, third parties that they're using. So we'll talk a little bit about some of those classification issues. We'll also talk a little bit about volunteers and interns. So I did see a question referencing both of those, and we know in the nonprofit space, those issues come up as well. So the second half is kind of dedicated to the non-employees that help you carry out your missions. So I'll turn it over to Sapna to kick us off.
Yeah, so again, we talked about employees. Now we're going to talk about independent contractors. And the thing to keep in mind here is these could be huge pitfalls. If somebody is an independent contractor, or they say they're an independent contractor or want to be an independent contractor, but are really an employee, we know that the government really scrutinizes that. And so you should really think about what that looks like. The one thing to point out here, at least one of them, is tests are different depending on the agency and the law. So state law may be different than federal law, and agency law is maybe another level on top of that. So keep in mind that we'll talk about 2 of the different tests today, but you want to make sure that you look at sort of a variety of different tests depending on what area you're working in. And independent contractors, those generally mean people who are engaged to perform services sort of free from the direction and control of the employer. So with the exemptions, we talked about, using discretion and direction and control. This is a little bit different. And so you want to make sure that independent contractors can sort of do most of the work themselves, And it's different than an employee and who may be more controlled by an employer in what they do. And so here too, you know, we talked about a number of different employment laws. And so just reiterating how closely the government scrutinizes these independent contractor relationships. And we've, at a federal level, we've seen sort of some of the tests have changed recently. So that's always something to keep in mind of, because there's always a conversation happening. And so you want to make sure that people are properly classified.
And this area is kind of an interesting one, because when people are independent contractors, true independent contractors, so there's never going to be an issue. As an attorney, I'm an independent contractor to my clients, right? I'm paid by 1099. I give them a W-9. I do something that they don't do. They don't control me. I have specific skills that I'm using that are outside the normal course of the employer's business. Not going to be an issue. You have a plumber, you have an electrician, you have someone who comes in and does executive coaching for your management team. So you run, you know, a space for individuals with development disabilities, and you have someone come in to train on specific aspects of skills. That's not what you do in the normal course of business. You're taking care of your community. You're not a teaching or training facility. You're hiring a trainer who's an outsider. Those are all going to be fine in terms of an independent contractor relationship. Hopefully they have their own business. Hopefully they have their own skills, their own equipment, their own email, and all of that. Where it becomes dicey is when you have people who, it's like an individual, it's a freelancer, someone who works for you primarily, sits at a desk, does exactly what you typically do as a workplace. You know, for example, if you have a development function and you say, you know, we have 5 people who are raising funds, but we want to have, you know, someone who's focused on large gift donors or something like that. And so we have too many employees. We're just going to hire an independent contractor to work here for 40 hours a week. But for all intents and purposes, it's really just an employee. That's a high risk relationship to enter into. And the reason is because when you engage an independent contractor, nobody's paying the government, nobody's paying the IRS, nobody's paying for Social Security, Medicare, nobody's paying into the Connecticut Paid Leave Authority for paid leave purposes. There's no workers' comp, there's no unemployment. It's cheaper for you. But if you get caught, it's extremely expensive. The way that we see this get caught is someone works for you and then you decide to part ways and they try to collect unemployment. So the Connecticut DOL says, hey, we have no record of this person, what's going on? And so when they get involved, they'll actually go through the different tests. There's a specific test that unemployment uses that we have up right now. And they'll start to say, well, was the person independent? Were they free of your control? What kinds of services were they providing? Was it basically the employer's core business, or were they providing something else? Were they sitting at a desk at the employer? Were they on site? And then they'll ask the third question on this slide, which is, do they have an independent trade, occupation, business? This is called the ABC test. It's unique to Connecticut unemployment, but most agencies have a test and they'll use that test. So if something comes across their desk, they'll get out their test, they'll run through it. And if you fail any of the factors, typically they're going to reclassify the person. And again, this is an expensive area because you probably owe whatever agency you get in trouble with. Like if you owe unemployment, you're going to be paying the Connecticut DOL several years back for anybody that was classified as an independent contractor who should have been an employee. So there's kind of a lot to know about here, but the one thing I would say for any nonprofit is if you have people, and you sort of know who they are because they stand out, if you have people like this that are basically engaging in the core business of the organization, like your mission is to provide teaching services. So you have some teachers who are on payroll, but then other teachers who are independent contractors, probably a problem there. And we'll go through some of the common ways that at least these come across our desks. But that's one of them. It's like an individual who doesn't have a business, that isn't open for other clients, basically just works for you, shows up when you want them to show up, is under your direction. Probably somebody who should be classified as an employee and not as an independent contractor. People always raise the IRS. The IRS has its own rules. So there's focus on kind of three parts about the behavior, the financial control, and just the relationship between the two parties. And they'll go through easily a ton of different factors. It's really like a totality of the circumstances test. And the more it looks like that person really just works for you, the more at risk we are that they'll say, nope, that person really was an employee and was misclassified.
Abby, maybe you'll get to this because this has happened a few times, but one thing that I've sort of seen or absorbed over the years is that if you're more likely to be safe if the person that's providing the services has an LLC or a company or a business. So your contract is with an entity rather than an individual. Would you say that that's the case?
Yeah, Priya always has the best questions. That's to some extent, yes. I just had this conversation, this exact conversation with a client actually about whether or not you're insulated. Of course, the answer to that is no. But if you have a business, usually it improves the other factors too. So if you have an LLC, you probably also have a website. You probably are open to other business from other people, and so you're holding yourself out as I am a, I'm trying to think of like if I train executives and I have a website, well, clearly I have other clients or I'm trying to get other clients. I'm running my own business. It's independent. I'm skilled. I do something other than what my clients are doing. They're hiring me for something specific. So in that sort of totality of the circumstances, I always feel better when you have an independent business. If somebody is basically an employee, but says, I'm going to have an LLC just because that looks better. So in my example, where we have a development department, 5 people are actually employed and working on, work directly for the organization, but then 3 or 4 people work 40 hours, have no other clients, absolutely don't have another business, but are smart enough to get an LLC. I'm like, no, that's not insulation. That's not going to get you anywhere. But yeah, I like having that as part of the mix.
All right, thanks, Abby.
So this was meant as a little bit of a test, but I won't put any of you on the spot. So which of the following could create a little bit of risk here in terms of misclassification? So the first one, an organization is organizing a trip to China and engages in individuals to teach language and culture classes before the trip. This one I've had. That's not going to be an issue. I'm assuming that this is, an organization that has a group of students that are going over to China. Maybe it's a Habitat for Humanities where they're going to be working on some sort of mission or some sort of project. So somebody who comes in and teaches about language and culture, well, that's not what our organization does. Probably not going to be an issue, assuming this is someone who holds themselves out as someone who's competent, who teaches the language, teaches culture. In my book, low risk. The second one, organization's mission is to provide translation services to other nonprofit service providers to ensure that they can communicate with their clients and consumers. Some of the translators are employees and some are independent contractors. Hopefully you're all saying this is a risky proposition. So when the independent contractor is doing the exact core business or core work toward the mission, that's usually going to be problematic. So if this organization exists to provide translation services and they've got employees who are translating, that means that probably anyone who's providing translation services day in and day out, where the organization is their only client, that's going to be risky to try to characterize them as an independent contractor. Now, contrast that by maybe this organization only provides Spanish translation services. They have a cadre of Spanish translation specialists who all translate. And once in a blue moon, they need someone to translate into Mandarin. So once in a while, they hire someone who provides this work for a lot of other nonprofits and gives them a couple hours of time. That's probably not going to be an issue. That's different. That's someone who they use as needed, someone who has their own business, and the organization's mission is to provide Spanish translation services. So it sounds like I'm in the weeds a little bit as I'm talking, but that's kind of what you want to go through to figure out what's the risk here, what's the person doing, and if they're doing your core business and they're working alongside people who are employed by you, who are doing the same thing. Those are some of the biggest hallmarks that show that this is probably not an independent contractor relationship. The third one, an organization engages an individual who has a facility maintenance company to power wash the outside of the summer camp cabins. I thought that this was on brand in terms of the time of season. The organization has maintenance personnel, but this is a job that's larger, requires additional equipment and materials. Low risk. This is not someone who should be employed by the organization. It's someone that has specific equipment, someone that has a business. And I'm assuming the organization has typical maintenance personnel that might paint, that might, work on scuffs and things, but not someone who has like power washing equipment. Well, that's sufficiently different. I would consider this on the low risk side. And the last one, an organization's development director is retiring and is offered to train his replacement. He is requested to be an independent contractor, only working 20 hours a week. How do you respond? If we were in person, I would ask all of you how you would respond. In this forum, I can't do that so easily. So I'm going to tell you this comes up all the time in the nonprofit world. Somebody's transitioning, someone says, I'm willing to help out. The one way this could work is there are people who provide independent contractor services across the board to different nonprofits. So there may be someone that provides consulting, someone that says, I help with development across, tons of nonprofits. If this person is that, where they have a business, they provide this to multiple clients, they hold themselves out in that way, maybe even then I think it's a little bit gray. In my example, where someone is going from being employed to all of a sudden being an independent contractor, that's a big red flag. How is it one day that they were employed and the next day they're doing kind of the same thing? They're training their replacement, but they're doing kind of the same work and the same role. It probably should be a red flag that should go up on that one. Okay, and I'll, this is me too. So just a quick slide on the risks and penalties. The risks here as well are very similar to the ones that we went through with wage payment. This ends up being a wage payment issue. So what happens when you reclassify is the whatever agency is that picked this up, that audited, and that now is looking into this, they're going to figure out how much you may owe. And the biggest issue is when an independent contractor is found to have been misclassified, the agency, typically the Connecticut Department of Labor, if they're looking at this for an unemployment perspective, they'll ask for information on anybody who's similarly situated. So we don't get off with saying, well, they caught that one, but we've got a bunch of others. They'll look actually through your whole general ledger and they'll look at everybody. I've had to produce tons of information on every independent contractor the client used, all the way from the lawyers you're using and the accountants to the trainers, in my examples, the extra maintenance that's being provided, all those services, and they'll look through it with a fine-tooth comb to figure out, is this someone who, played fast and loose, which ones were classified properly, which weren't, and you've got, penalties, fines. And this is a bigger issue also because the IRS now hasn't been paid. Our DRS here in Connecticut hasn't been paid for the time that's been worked by these independent contractors. And so it becomes expensive. And this is a hot area. I think Sapna might have said this, but this is an area that the government focuses on more and more. So just something to be aware of. And then I'll turn it back to Sapna.
All right. So we've heard a lot about employees. And so now just a note about volunteers, right? Volunteers are not employees, and you want to be mindful about what work volunteers are doing. Employees can't volunteer for their employees unless it's something very different than what their normal day-to-day work duties are. So like Abby talked about, are you sort of still making calls, which is what you may do on a normal day, or are you doing some offsite activity elsewhere? In a sort of different environment is sort of it's a good example of that. So I don't want to belabor the point, but you really want to make sure that the work is not sort of the same of the normal work duties of an employee.
And then we did pitfalls, because I think these are always helpful, most of which we've gone through. But again, if you have people who you're paying through 1099, doing very similar, the same services that you're providing. They don't have any clients. They work on site. They sit at their desk. If I walked by your office and I saw your employees and I saw your independent contractor, they look the same to me, fully integrated. So they might supervise somebody or they might be supervised by someone. They have a title. Those are the things that, one of those things doesn't necessarily mean that it's, a misclassification issue, but those are red flags. And if you asked me, these are the kind of questions I would ask. And if any are yes, then I would know that we need to dig and figure out if people have been classified properly. It comes up a lot, I think, in the nonprofit world with grant writing, with special projects, with events. Sometimes development departments will use independent contractors. Marketing departments might use them. Sometimes summer help, so summer camps, summer programs that are being run. Someone will say, "Oh, can I just hire 10 independent contractors? It's so annoying to add everybody to payroll." I get those questions constantly. So as that comes up, you always want to evaluate, like, is this the right thing to be doing for the organization? And sometimes people say, well, they're only working for 3 months. That's so silly that I'm going to add them to payroll. Well, these classifications doesn't matter if somebody works for 1 day, 3 months, or 10 years, whether or not, the government gets their cut of taxes and unemployment, workers' comp, all of that. It doesn't matter how long they're working for you. So sometimes when I have clients say, well, it doesn't make any sense to say, well, maybe a staffing agency, maybe that's a better way to do it. Maybe some temporary help from a staffing agency or something like that, that is lawful, but doesn't require you to put seasonal help on payroll or, project-based help. So, with a long list of other things that I know all of you have on your to-do lists, this is one that doing an audit or taking a look at it is sometimes really helpful and can be illuminating. Okay, so I think we have a final slide about interns.
Indeed. So note about interns. So under the Fair Labor Standards Act and the Federal Department of Labor guidance, there's specific criteria for an unpaid intern or a trainee. And so these 7 factors, I'm not going to read them all out, but these are evaluated to try to figure out whether it's an employment relationship with an intern or a student, as compared to, so whether they should be classified as an employee or an intern. So you really want to make sure that, again, you go through these factors and figure out what that looks like. For example, if an intern is getting academic credit, or it corresponds, the internship corresponds with the academic year, that weighs more towards sort of more of an internship. But the other thing I'll add is, when people ask about unpaid interns, that's something that we generally do not recommend unless there's some other factor that goes into that, because that can lead to issues sort of further down the road and potentially unintentionally triggering other factors. So those are things to think about, and the seven factors are definitely helpful in sort of deciding how best to proceed with interns.
Nice. So we are at the end. We have a couple takeaways that we'll leave you with. The one thing that I'll say, whenever you're kind of thinking about compliance and trying to figure out where do you start, I always say, and it's very basic, start wherever you think there's some risk. So if you heard anything today where you say, oh, yeah, we have everybody is exempt and we don't have time records, places like that is where I would start, and kind of make yourself a checklist of, like, we're going to get into compliance and we're going to start wherever you think those risks are. The other thing that I would say, and I know Priya agrees, is as you are looking at your pay practices, wage payment, if you identify issues, be really careful about writing all of that up and making lists for yourselves. So when you identify issues, you have to correct them because now you know. So just be prepared. If you say these are 10 things and we've done this audit, these are 10 things that we've got to work on, be careful about what you're putting in writing and be careful about your timeline. So once you know, you got to make those fixes. It's always better to have counsel involved. So to call a Priya, not only for, her expertise, our expertise, but also so that it's privileged and we can help in terms of making fixes, especially if they're more substantial. And that those communications are privileged, because that is, something that you'll enjoy if you're working with counsel, is the government knows that, look, you're working with your counsel, you're trying to figure this out, you're trying in good faith, but it is also privileged. So that's more of on a practical side than anything else. So I think I'll hand it back to Daniel, Betsy, Monica, Priya, but just want to thank all of you for being here today, for all the good work that you do. And again, we appreciate, all the ways that all the organizations here make the community better, especially in the Hartford area.
Thank you, Abby and Sapna, for such a great session. I ask everybody to please complete the evaluation form before you exit the room. A follow-up email will include a copy of the PowerPoint presentation and a link to the recording. And this concludes the spring offerings of the nonprofit workshops. We're going to be back in the fall. Enjoy your summer.
Thank you, everybody.
Bye.
Bye-bye.